At this time, I would like to call the meeting to order. Today is Thursday, July 25th, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tonga and Gabrielino Kizh peoples. Commissioner Topshin, would you lead us in the Pledge of Allegiance?
Sure. Please? Everyone, please rise and repeat after me.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, may we take roll call, please?
Yes. Commissioner Bass?
Here.
Commissioner Kirpies?
Here.
Commissioner Topshin?
Here.
And Vice Chair Moore?
Here. We have a quorum. Has everyone had a chance to review tonight's agenda?
I'll move the agenda.
Second.
We have a motion and a second. We take roll call to approve.
Yes. Commissioner Bass?
Aye.
Commissioner Kirpies? Aye. Commissioner Topshin?
Aye.
And Vice Chair Moore?
Aye. Motion passes. Approval of the minutes from the meeting of June 27, 2024. Has everyone had the chance to review the minutes from that meeting?
I move to approve the minutes.
I'll second. We have a motion and a second to approve the minutes.
Commissioner Bass?
Aye.
Commissioner Kirpies? Aye. Commissioner Topshin?
Aye.
And Vice Chair Moore?
Aye. Motion passes. Do we have any speakers from the public?
No public speakers at this time.
Okay. Next item is the manager report. Mr. Kissinger, may we have the report, please?
Yes, good evening, Commissioners. It's nice to see you all again. Tonight, we'll be hearing Appeal D-4837. We'll also be discussing the reorganization of the Chair and Vice Chair, Commission liaison appointments to other Commission's advisory boards, and a presentation from staff on proposed amendments to the Rent Stabilization Ordinance and Rent Stabilization Regulations. Just to clarify here, there's been a small change from what was published. Staff is actually going to move what was previously listed as being on August 22nd to August 8th because there's a concern we may not have quorum on August 22nd, and per regulations and the code, we are required to announce the security deposits valuation guidelines prior to September 1st. So just in order to ensure that those announcements are made, we will plan on having the presentations on the interest rate on security deposits and the valuation guidelines on August 8th instead of August 22nd, as well as Appeal D-4849. On August 22nd, we will likely be postponing that meeting due to the quorum issue, but the hearings will probably be delayed pursuant to that, but tentatively scheduled right now is D-4846, September 12th, D-4865, September 26th, D-4876, October 10th, D-4869, and D-4851CD, and then October 24th, D-4831CD, and D-4884. Again, likely these appeal schedules will look a little different because they'll be pushed back, but we'll get that to you soon. Yeah.
Okay, thank you. Now we're at the appeals portion of our agenda. We have an appeal before the commission this evening, D-4837. Do we have a representative for the tenant and landlord?
Yes, they're both present via Zoom, and let me admit them into the meeting room.
Okay.
Okay, it looks like they're connecting.
Okay. First, we'll hear. Do you want me to wait until? I'll wait until they're both here.
They're both in.
Oh, they're both.
They can
in.
hear you now.
Oh,
Yes.
Okay, great. First, we'll hear a staff report from our legal counsel. The appellant will speak first. You will have 5 minutes to provide your oral argument. You have the option of dividing your 5 minutes into 2 segments. You may use part of your 5 minutes to state your case and part of your 5 minutes for rebuttal. The respondent will speak second. You will have 1 5-minute segment to state your case on the appeal subject. When it is time for you to speak, please state your name and the city of residence for the record. The appellant will state how you would like to divide your time, if at all, and proceed with your comments. Since your speaking time is limited, it is very important to keep the following in mind. Keep on topic. The only information you should share should be about the appeal topic. New evidence cannot be considered by the commission. You may only discuss issues that were raised at the hearing or evidence submitted to the hearing examiner. Legal counsel, may we have the staff report, please?
Good evening, Chair. Good to be back with all of you. My name is Kellen Martz. I'm legal counsel to the Rent Stabilization Commission. It's fun to be on this side of the aisle now and see how John did things. I have big shoes to fill, but we'll take it one step at a time. So, in this appeal, D-4837, this is resulting from a rent adjustment hearing on multiple issues. I'm going to defer to the staff report on this because there are about a dozen of those. However, the tenant was awarded a rent reduction in this matter, as well as on common area items. So the rent reduction resulted in interior painting, $41, broken blinds for $10, window screens for $5, exterior painting for $46, which is the common area item, and baseboards and hardwood floors for $40. Landlord filed the appeal, which claims that the decision is in error. Staff finds that the decision is not in error and that there is substantial evidence in the record to reasonably support the hearing examiner's decision. On this matter, you have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard. This requires the commission to make sure that there is substantial evidence that reasonably supports the hearing examiner's decision, is credible, and of solid value. If that evidence is found, then the decision must be upheld, even though there may also be evidence that could support a different outcome. The commission does not substitute its own judgment for that of the hearing examiner or reweigh the evidence. In this matter, it is not a question of law, it is a question of fact. However, in those cases, the commission applies an independent or de novo standard of review for the hearing examiner's conclusions of law. Thank you.
Okay, thank you. Do we have the landlord present
Yes.
as the appellant to speak?
Nydia would be the first one to speak. Nydia, if you can hear us, can you please let us know how you would like to divide your time, and then you can proceed with stating your first and last name and your city of residency. Hi, Nydia, can you hear
Hi.
us?
Yes, I'm here.
Okay, and how would you like to split your time? You have 5 minutes. You can split 2.5 minutes each, or you can do 3 minutes, 2 minutes, or you can take your full 5 minutes.
No, I think that I wouldn't take much time just to speak.
Okay, so I'll start the timer for 5 minutes, and then just let me know when you're done, and I'll go ahead and stop the timer, and I'll let you know how much time you have.
Okay, no problem.
Okay. And then please start with stating your first and last name and your city of residence for the record, and then you can go ahead and start.
Sure. My name is Nydia Lobos, and the city that I resided is in Hollywood.
Okay, and go ahead. You can go ahead and start with your oral argument.
Well, the reason why we're appealing the case is after the last time that we had our meeting and the tenant stated all the things that needed to be done in her unit, we went back and we actually rectified everything. We placed new blinds, new window screens. We painted inside the unit, and we also painted the hallways and common areas. And currently, we are in the process of painting the outside of the building. And that's it.
Okay, you have 4 minutes and 20 seconds left. If you would like to use them after the tenant gives their oral argument. So I'm going to go ahead and mute you for now.
I have a question.
Okay.
Oh, my apologies. We actually have Commissioner Bass here, and he has a question for you. And this time isn't used against you.
Okay, sure.
My question, just to clarify, you said that you've gone back and done some of that work that was discussed during the hearing. It all happened subsequent to the hearing, is that correct?
Yes.
Thank you.
Any other questions? No? Okay.
Do you want me to?
Yeah, go ahead.
Okay. The tenant is Christina, correct?
Yes.
Christina, you have 5 minutes to speak. Please state your name and city of residence.
Gerasi, city residence is West Hollywood.
Okay, you can begin.
And I agree with the committee's decision and I have no further comment.
Any questions from the commissioners? No questions?
No.
Nydia, would you like to add any other oral arguments to the record?
No, I do not.
Okay. We may start deliberations. Does anyone want to start? Okay, Commissioner Kirpies?
Yeah, I see this case as a misunderstanding, maybe on the landlord's part of what their responsibilities are, but I appreciate the fact that they have gone back and maybe resolved the issues, but the hearing examiner did issue a hearing or a decision that reduces the amount of the MAR, and until those items are fixed, then that stays in place. But our role here tonight is to decide an appeal of whether the hearing examiner made a mistake or made an error in the decisions they made during the hearing. And I do not believe that they did make any errors. So I would be voting to affirm the hearing examiner's decision and uphold their decision. And I would recommend that maybe staff talk to the landlord after the hearing to explain how they would go about filing a compliance determination so that they can resolve the issues. Thank you.
Thank you, Commissioner Kirpies. Commissioner Bass?
Yeah, I echo what Commissioner Kirby said here. It seems like most of the evidence in front of us tonight would really be handled through a compliance determination and not through an appeal. If these items were rectified after the hearing, then a compliance determination, not an appeal, is the way to resolve this issue. Just reiterating what Commissioner Kirby said, our role here is to see if what the evidence that the hearing examiner looked at, if a reasonable person would have come to that same conclusion. And what I'm being told is that the remedy happened after the hearing, so the hearing examiner made a very reasonable decision. The only thing I would point out is that in the appeal, there was an argument about painting the exterior of the building and a reference to what inspectors had said. And I would just encourage the landlord to pay attention to what the hearing examiner's decision said, not what an inspector is telling them verbally, because that would be the document that the future hearing examiner will review for a compliance determination. And I don't want to prejudge that in case it's ever appealed to us, but please look to the hearing examiner's decision on the exterior painting. But other than that, I'm voting to affirm the hearing examiner's decision.
Thank you. Well, I concur with my fellow commissioners what they have said in regards to the determination, findings of the examiner. The findings are correct based on the record evidence, and I believe the examiner didn't err. And if there was work done after the hearing, so that would be a compliance determination that the landlord has to file for, a request for compliance determination in order to restore the rent. But other than that, I don't see the examiner's error in the original decision. So therefore, I'm going to affirm the staff's recommendation. Thank you.
Thank you. I agree with all of my fellow commissioners as well. I do think that this was possibly a misunderstanding of an appeal versus filing a compliance determination. So I will also be voting to uphold the hearing examiner's decision. Do we have a motion?
I could make a motion to adopt resolution of the Rent Stabilization Commission 24-651, a resolution of the Commission of the City of of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision as to application number D-4837.
I'll second that.
Okay. Commissioner Bass?
Aye.
Commissioner Kirpies?
Aye.
Commissioner Topshin?
Aye.
And Vice Chair Moore?
Aye. Motion passes. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. For the parties who joined us through Zoom, which are both of you, you will now be placed back into the waiting room. If you would like to watch the rest of the meeting, you may find your options to do so at weho.org/WehoTV. Thank you so much. Now for new business, we have item 9A, proposed amendments to the Rent Stabilization Ordinance and Rent Stabilization Regulations.
Yes, thank you. So tonight I'll be presenting on two proposed amendments to the Rent Stabilization Ordinance and several amendments to existing regulations. The first of those proposed amendments is the adoption of Assembly Bill number 1620. Just to provide some information about the Assembly Bill, it became effective at the state level on January 1st, 2024, and it amends the Costa-Hawkins Rental Housing Act. It allows municipalities to require landlords to relocate tenants without a change in their maximum allowable rent or the terms of their tenancy under certain conditions. Those conditions include that the tenant is not subject to eviction for non-payment of rent, that the tenant has a permanent physical disability that relates to mobility, and no elevator access to their current floor of residence, that the move is necessary to accommodate that disability, that there is no intent on part of the owner to have them or an owner relative occupy that unit, and that the new unit proposed by the tenant is in the same building in the parcel, and that there are 4 or more units in that building or parcel. The second amendment to the RSO is an amendment to RSO section 17.52.01013. This section authorizes a landlord to evict a tenant or tenants where a unit will remain uninhabitable beyond 6 months. However, per the City Council in a different section of the code, there's a 3-month limit for temporary relocation where a landlord needs to make fixes related to habitability. And that was adopted as Ordinance 21-1149 on May 3rd, 2021. The intent of the City Council in adopting this was to protect tenants from prolonged temporary displacement or from an unknown period of displacement in the event of a habitability issue with their unit. That ordinance amended RSO section 17.52.110. It does provide extensions upon request by the landlord as necessary, depending on the nature of the repairs. But the suggested amendment is important in order to bring consistency between these provisions and fulfill the council directive on that item. Just to illustrate, because when talking about different code sections, it can help to visualize this. This is what was amended from 6 months to 3 months. You can see it's under temporary repossession for authorized corrections, and I highlighted the portion that states that within 3 months of the start of a tenant's displacement, the work must be completed unless the landlord can request and demonstrate a reasonable basis for necessity of an extension. This is the proposed change. So you can see the changes, the old language crossed out, and then the changes next to that. Essentially, it's just modifying the 6 to 3 months and adding the language from the other code provision regarding the ability to apply for an extension on a reasonable basis. There is also an proposed amendments to RSR 20001. RSR 20001 currently requires that changes in ownership and management be provided to the city within 60 days of that change. However, RSO section 17.28.010D requires that information be provided to the city within 30 days. The ordinance controls, so the regulations need to be brought into consistency with the municipal code. There are also proposed amendments to RSR 60002. RSR 6002C imposes a 30-day maintenance request timeline for reduction in services hearing applications. The amendments in question relate to the initiation point of that timeline. So currently, that 30-day timeline can only begin at the actual removal of a service. This proposal would allow the initiation of the timeline at notice of removal. So for example, if the notice is 30 days or more, then upon the actual removal of that service, the appeal can be filed under these amendments. It also incorporates an automatic inclusion of a MAR determination hearing where registration or re-registration violations exist pursuant to Municipal Code 17.28.040. The current practice is to simply advise both parties that there is a re-registration violation. However, these amendments are intended to allow for greater enforcement of re-registration noncompliance and make that automatic. Finally, there's a proposed amendment to RSR 60041.1. This relates to the valuation guidelines, which we'll be bringing before the council, or before the commission, excuse me, shortly. They're increased by the annual general adjustment annually, pursuant to the City Council's directive in 2022, which was a result of a commission recommendation. It became effective, these increases or adjustments based on the AGA in September 2023, and now those adjustments are made before September 1st annually, effective September 1st. And they're used by hearing officers in reduction in service cases to determine what type of reduction should be given. The adjustments are currently rounded to the nearest dollar amount, but in effect that means that smaller values never increase. So this amendment proposes a minimum of a $1 adjustment to either end of the range annually to ensure that the lower and higher ends are changing in some way or increasing every year. And that completes the presentation, but I'm open to any questions you might have.
Commissioner Topshin.
Thank you, Madam Presiding Chair. Good evening, Mr. Manager. A couple of questions I have in regards to that AB 1620, the amendment to the ordinance based on the Assembly bill. Specifically, my concerns are, and I'm reading here, the size of the comparable, what the comparable unit is defined under this particular subsection, a comparable or smaller rental unit. So, in a hypothetical case scenario, if a tenant lives on the second floor, let's assume that's the top floor, and it's a 2-bedroom with a beautiful balcony and a view, and now the tenant has to move to the bottom, the first floor, which is only available is a 1-bedroom, and no balcony, no view. So how that can considered a comparable unit? I know it's probably legal definition type of thing, but I don't understand how that can be considered a comparable unit.
So the intent, and this is tenant initiated, so the idea is that the tenant has a physical disability that impedes their mobility and their ability to access their unit. And if a unit becomes available, the idea is that they're able to move into that unit at their sort of choice, if that's what they propose as an accommodation for their disability. So it wouldn't be a situation where a landlord could say, no, I want to move you into this less desirable unit. It would have to be that the tenant wanted that and also needed that on account of their disability.
Okay, which was basically answered to my second question, which was this process can be initiated by the tenant.
Yes,
not by the landlord.
Yeah, it's the tenant requesting an accommodation in this case.
Okay, so that answers to all other questions. Good, let's see how it will work out. But it's the Assembly bill. I guess there's nothing else we can do, but yeah, and legal counsel want to add something.
Yes, and I just want to add in the definitions and the way this was crafted for the city of West Hollywood is constrained by the AB 1620. So we're using the exact same language of comparable or smaller unit. So that's why when I saw it the first time, I was like, oh, that's terrible. You're going to go from 700 square feet to 400. But again, as the manager said, it's tenant driven. So and it's not going to happen very often. So staff is going to be very clear to watch if and when these things come through.
Great, thank you. And Mr. Manager, what will be the process of kind of monitoring this checking if everything, there is no pressure by the landlord, although the tenant submitted the request, but maybe behind the scene, this was landlord's doing. How can we, verify that's not the case?
Yeah, so all of the existing protections of the RSO apply, and certainly discretion on staff's end would be warranted here. We have our anti-harassment protections where landlords are unlawfully trying to evict a tenant, so certainly we would be conscientious of any pressure from the landlord or any attempt to utilize this provision intended to protect tenants to actually harm tenants in some way.
And can we consider this process to be, whatever the application process will be, filing with the city, that the information will be distributed in Russian and Spanish as well, because people who don't really speak English or Spanish, so they wouldn't be coerced to sign something without knowing what they signed?
Yes, absolutely, and that's standard practice for anything distributed by the city and to tenants from landlords. That's required by the city.
Okay, great. Thank you.
Mm-hmm.
I have a couple quick questions. On the notice of change in landlord or manager, what is the enforcement mechanism? We're saying they have to let us know within 30 days, but what if they don't?
Mm-hmm. If they don't, then that is a re-registration violation. One of the intents is, of some of these changes, it relates to another change, but the tenant can reach out and schedule a hearing for their MAR, and the landlord would not have been able to impose, while they were deficient in their re-registration obligations, any rent increase. And so the tenant can move forward and say, okay, well, I was charged even though the landlord's deficient, and my rent is actually lower at this point, or it should be lowered. In terms of enforcement action, landlords are subject to citation or referral to the city prosecutor if they're not compliant with all of the re-registration compliance requirements, including the requirement to update owner information within 30 days.
Thank you. Mm-hmm. And the next question is, in the notice of removal of a housing service, I'm thinking parking spaces is probably something that would come up here, although I know that gets complicated because there's other rules about that. The building across the street, they got rid of the pool. It actually looks a lot nicer now without the pool than it did before. But when they got rid of the pool, they let all the neighbors know. Why are we waiting for it to actually be removed? Let's say they give 60 days notice, and the tenant says, no, I don't want you to get rid of this particular feature. Again, I'm not going to use the place across the street, just so we're not talking about a specific example, but they say they don't want that. We're going to wait for them to actually take it out or remove the service before they can file, even though we have it on notice that the landlord is not backing down. So they give 60-day notice, we're going to get rid of your this housing service, and 30 days go by, the landlord says, no, I'm actually going to move forward with this. We're still going to wait for that to actually be removed before.
Yes, I think the actual removal is required just because the scheduling of a hearing on the basis of a proposal to remove something, I don't know that the hearing officer would actually be able to take any action or reduce any rent amount based on a proposal. It needs to actually have been removed for the eligibility to exist for a reduction in rent. But this does have the intent of shortening that timeline so that the period of time where there is actually a reduction in that service without a commensurate reduction in rent is shorter.
Yeah, I appreciate it. I think this is going in the right direction for sure. Let me use laundry services. They're going to get rid of their washer and dryer. That's a housing service. I don't think anyone would argue getting rid of washer and dryers, getting rid of a housing service. But now I have to deal with, for a period of time, from the time I filed to the time of the hearing, and the hearing examiner's decision comes out, can be a couple of months of going to the laundromat. So that's why I was trying to think of those sorts of examples of the hardship actually could be stopped if we moved it forward sooner. But I hear what you're saying about the examiner. I have no objection to what it is here. I think it's a step in the right direction. I just wondered why we weren't just doing 30 days, period. Thank you.
To follow up on that, actually, why can't we do it, why do we need the 30 days if they're removing a service? The landlord should already know that the laws here require them to reduce their rent if they're removing a service. So why couldn't we make it the day that they removed it, filing, considering that they've already noticed the tenants, so there's already been dialogue back and forth, it's going to be removed. Why do we have to start a 30 days period during that time? Why? I do understand why we'd have to wait till the service to actually be gone for the hearing examiner to act, but.
Yeah. I think the goal in the 30 days is to ensure that the landlord has the opportunity to remedy that, and that it's a longer-term reduction in service, and it's not something that, for example, would be gone for 10 days or 15 days before a hearing could be scheduled and is then returned, and that would render the hearing superfluous or create challenges, for example, with the actual scheduling of hearings if they're constantly being canceled because it's not actually a long-term reduction in service that would make sense to have a rent reduction for.
I think we're more likely to see the back and forth like that remedies in cases where I don't have electricity in my bathroom or something, situation like that, than we are than to a landlord who's noticed their residents 45 days in advance that the pool is going to be removed or something. They have that time to come up with a remedy, and if they haven't, then the hearing examiner should be able to I mean, I think the hearing examiner should be able to act immediately. The tenant shouldn't have to wait any longer to file. I'm just wondering why we're still holding them accountable for this 30-day thing.
Mm-hmm. Yeah, like I said, I think that's the idea. I am certainly, like, this is the amendment that's being proposed now. There are certainly, it's an ongoing discussion of what our regulations look like and what future changes might be in order to benefit tenants. That's just the rationale, as I'm aware of it, for this 30-day timeline as it was written in these regulations.
So who's proposing this amendment?
Staff is proposing this amendment. It includes the 30-day timeline, but the intent is what the commissioners are communicating here, which is to allow the hearing to take place without so much time passing upon actual reduction of the service.
Mm-hmm. So on this one particular, I agree that I like the direction that we're heading, but if we can chime in, I would say that we recommend, if my colleagues agree, we recommend that there be no requirement of a 30-day waiting period or countdown, whatever you want to call it, when the landlord is noticing and then affirmatively, as of the language here, affirmatively refuses to perform the work to remedy it, so that as soon as the noticed service is removed, that same day, a hearing can be filed to reduce the amount of time that the tenant is going without the service and no compensation for it. But I'd have to get my colleagues to agree to that. I have a couple other questions on the first one, or no, maybe it's the second one. The 3 months to 6 months, I completely understand why we'd want to do that and why we'd want to bring our two ordinances, or our ordinance and our regulations in line. But it sounds to me, the way you explained it, that 6 months is when we had the 6 months rule, it allowed tenants to stay there for 6 months before the landlord evicted them outright. So the landlord would have to pay for them. If the landlord were doing some maintenance and the tenant wanted to stay as a resident and come back, the tenant knew that for 6 months the landlord would have to pay for their relocation, or not, I don't know what we call it, the temporary displacement fees. And then at the end, the landlord could only evict them after 6 months, or if their project was going to last more than 6 months. Under this, I'm understanding that only if we change it to 3 months, I do understand that provides some stability to the tenants, but it sounds like the landlord is the one that's in full control of whether to ask for an extension or not the tenant. So that to me means that the tenant only gets 3 months. In both cases, they can leave early, but in many of these cases, the tenants do want to come back. They do want to stay in their apartment that they had. Mm-hmm. So I'm worried that this is actually going to potentially be used to evict tenants, not to just rehab and then let them move back in.
I definitely understand that concern, and also to clarify, under this provision, all tenants have a right of first refusal to return to their unit at the same MAR with any allowable increases under the AGA. So it's not a situation where tenants who actually do intend to come back would not be able to do so. They're able to do so and at their same rental rate, same terms of tenancy. Mm-hmm.
At their expense, though, right?
So while tenants are temporarily relocated due to a project, that is covered by the landlord. If they're evicted, they're paid the relocation fee and they have the right of first refusal.
Okay. Still think there's a, okay.
Is that a first,
go ahead.
sorry, just while we're on this, is that a first of right refusal to come back for the new rent?
No,
what
it's
you're
the
saying?
same MAR.
It's
So
the
it
same
would
MAR.
allow any adjustments that would have taken place in that time, but it would be protected. It would be rent controlled.
Okay.
And how long does that right of first refusal last?
It's not specified in the code, so presumably for as long as the period of construction takes. Yeah.
So they do construction for 6 years, you could come back 6 years later.
It's not specified in the code, so it would presumably, yeah.
Okay, I'm not trying to hold you to anything, but that would be within the realm of possibility.
Yes.
Thank you.
In other cities, there is actually a number of years there, but what is required is that the tenant maintains an address on file with the landlord, so that they can send them a communication saying the work has been finished and we're giving you the opportunity to come back. So, problem being tenants move and things like that. But yes, I don't know what would happen in 6 years. I hope we never see that. But yes, the process would be they would need to make contact with that tenant, so long as they've provided an email address or an address, and provide that opportunity to return.
Forgive me for being extreme, but it was the intention.
It helps the question.
But also the landlord's only responsible to pay them for their temporary housing up to 6 months?
The period that a unit must remain uninhabitable in order for this eviction to be allowed is 6 months currently. It's being changed to 3 months. So that's not necessarily the same thing as when the tenant would be evicted. It's just that the work itself has to take place for at least that set period of time.
And
So I'm thinking
above-
of the,
And above that period, that's what triggers the permanent relocation with the right of first refusal. That's what you're saying?
Correct.
And the relocation fees are the same as for no-fault eviction relocation monies?
Correct. And the idea here is just the council has said temporary relocation of tenants should not take longer than 3 months. And so it's just the concern about saying, the council saying, okay, well, this shouldn't be taking longer than 3 months, but if it takes longer than 6 months, then you can proceed with this just cause no fault eviction.
So longer than 6 months?
6 months is the current code provision. Aligning them would be changing it to 3 months based on this amendment.
Right,
Yeah.
right. Okay.
so how would this apply to, like, let's say the building that's so controversial in Los Angeles that the tenants get to stay now, but for the last 2 years, the landlord wanted to do construction. There was a big fire in the building. They wanted to redo construction, and they were saying, we have no other choice but to kick out to evict all the tenants. How would I don't know how long the city of Los Angeles has for their period before they can kick them out, but they were at that point where the landlord was evicting people because it was too long of a project for them to, they claimed, too long of a project to pay for temporary relocation for everybody. So I'm just curious, like, if we had a building, a rental building here that wanted to do some upgrades and like, oh, look at this, it's gonna last 9 months to do all of our, or actually now under this one, it's gonna last 4.5 months to do all of our upgrades, which is not unreasonable. They're gonna evict everybody, pay them relocation fees, and then those tenants who may want I mean, it's very expensive to move, and so the relocation fees that they get, I don't think, if they saved them, maybe it would help them move back in, but I'm just concerned that this is not enough, that the landlords can utilize or bend this to their advantage, and that's my concern. But I agree with aligning it, doing the extensions of a 3-month. No one wants to be sticking tenants in a temporary relocation for 6 months, but I think the tenants have more control in that situation than what we're implying or we're thinking that they do here. But those are my thoughts on that.
I guess to echo what you said, Commissioner Kerpis, so the city sets this 3 months, but will the department or maybe the code enforcement, whoever the body will be, would they monitor or look into the project, what is proposed, how long it will take, or it's just up to the landlord basically to decide? Because since Commissioner Kerpis mentioned, for example, City of Los Angeles, I know they have a program that is called Tenant Habitability Plan, which the city would set a projected start date for the work, for the project, and the projected end date. So they would know from the beginning how many days it should take. So I'm wondering if that's will be the similar process for in our city. So for the department, for the city to be more involved before the project will start.
Yes, I think that's the idea, and just the idea also that if it does extend longer than 3 months, that has to be justified. So there will be discretion applied by the city on whether that makes sense, collaborating with other departments and divisions to ensure it is a justified extension.
Okay, so that's great. It's not just the landlord says, the project will last 4 months or something, because that will automatically trigger evicting the tenants.
Yeah.
Got it, thank you.
I was deferring in case you had comments. I hear what my colleagues are saying, and I'm wondering two things on this one we're discussing now. I recognize the council has passed an ordinance, and ultimately they are the policy-setting body in the city. All we do is advise them. But what about advising them of changing it so they align at 6 months as opposed to 3 months as one option? And then the other one, the notice to remove housing service. I hear Commissioner Kerpes and I are probably about the same place on this. Currently, you have to wait 30 days to apply for a hearing unless the landlord writes back to you and says, no, I won't do that, right? Like if you have a written notice. So when the landlord says, I'm going to be removing the pool, the laundry facility, or whatever it might be, and you say, no, I don't want you to remove that, and they say, well, I'm going to do it anyway, isn't that enough to trigger them to be able to file a hearing and not have to wait the 30 days or wait for the item to actually be removed? Wouldn't that kind of fall in that same sort of category? So I know I took you two different directions, but I want to get both thoughts out and not forget them.
So I think that's what I'm trying to say in so many words is, right now we would allow that, and even under this policy, it's my understanding that if the tenant said, "Hey, don't take my pool away," and or compensate me, then the landlord turned around and said, "No, I'm going to take the pool away." I think that response would trigger it to allow that they no longer need the 30 days, right? The response back saying, "I'm not going to remedy this. I'm going to remove the service, but I'm not going to remedy it," that automatically gets rid of the 30 days. You can file then, is my understanding of both current policy and this new policy.
Correct.
Okay. And then, so what I'm saying, though, is this new policy still requires, even though the landlord's going to say, I'm taking your pool away, I'm ad-libbing here. I'm saying that I believe that it's the landlord's responsibility to know what they are required to do when they remove services. So I'm going to say, what I'm trying to argue is that we don't need the 30 days. Once the pool is removed and there's no remedy, it can be filed. Like the tenant doesn't need to go out of their way to say, "Hey, don't take my pool away," or pay me, and the landlord say, "No, I'm going to take your pool away," or "I'm going to think about it," or "We'll see. That's a good point. Who knows?" But the pool goes away. Doesn't matter how many days. The landlord has responsibility from that day forward. This is a little bit different situation than my lights go off in my apartment and I'm calling the landlord saying, "Hey, my lights are off, come fix it." They do need time to repair, to remedy that, but this is their doing. So that's, and to make my more formal recommendation is, I'll need staff's help, but if you look at the staff report, if I just use the staff report's wording, on page, where is it? I just had it. On page 157, in the paragraph that talks about this, about four paragraphs down, an issue has occasionally arisen. in the middle of that paragraph where it says staff's proposed amendment would allow a tenant to serve their 30-day notice anytime following receipt of information that a housing service will be removed, and if the service is in fact removed and 30 days has been elapsed since the service of the tenant's notice or the landlord has affirmatively indicated. I just want to remove and 30 days has elapsed since the service of the tenant's notice. So I would say that staff should be proposing an amendment that would allow housing service allow a tenant to serve their 30-day notice anytime following receipt of information that a housing service will be removed, and if the service is in fact removed, or the landlord has affirmatively indicated that will not be restored, then the tenant proceed with rent adjustment application. But I would actually even remove the tenant submitting the 30-day notice in the beginning. So that would be my, I guess, a motion for this commission to consider.
I did want to note that we did receive a public comment request, so before the commission takes action, we should hear from the public commenter.
Okay.
Are you ready for the public
Yeah,
commenter?
you can come up.
Rick, go ahead and come up.
Good evening, Commissioners. Rick Watts, City of West Hollywood. With respect to the first matter, I'm in concurrence with Commissioner Kirby's on this, and I'm relating to our experience over at 1264 North Sweetser, a property that was purchased 4 years ago by a company named Veritas Investments, a large REIT up in the Bay Area, with multiple properties down here now as well. They, among other things, removed our security cameras in the building. And we were told repeatedly over months and months and months that they were going to be replaced. Well, it never happened, but they dragged the process out so long that people kind of forgot about it. In the meantime, we've had like at least 3 mail burglaries, and so the ability to for a landlord to keep making promises can drag the process out to the point where nothing ever happens. With respect to the other item on relocation and the changing of 6 months to 3 months, or altogether to 6 months, it seems to me another remedy if nothing is done, then the incentive, because a tenant being forced to relocate because things get drawn out, repairs get drawn out for so long, either by design or it just happens that way. And they move to another apartment. It's very difficult for somebody to move back, even if they want to. There's expenses involved that are not right now, as I understand it, are not reimbursed. So it seems to me one of the things that would help to incentivize or disincentivize landlords from dragging the process out, and to incentivize them to hurry up, get your dang repairs done, would be to also require them to pay that tenant who has the first right of refusal to relocate the tenant, for the landlord to be required to relocate the tenant if the former tenant chooses to move back in and take advantage of that right. Because otherwise, just the hassle and the expenses of moving back in can be prohibitive for them to even take advantage of that right. My suggestion for you to consider. Thank you.
Thank you.
Chair, may legal counsel make a few comments?
Absolutely.
Okay, great. So, Commissioner Kirby, I want to go back to your example of the 4.5 months work, and that's kind of the in-between of right now we're at 6 and 3. And so I was mulling that in my head, how that would work when someone would come in and apply for that. Right now, 6 months is the outside window. The work takes 4.5 months. So the tenant that must temporarily exit their apartment is being covered in an apartment or a hotel for those 4.5 months, but that's all they get. In this, if this goes through and it's changed to 3, that same tenant, now the work is 4.5 months, they will be evicted, but they will get the relocation funds, which are, $16,000 to $24,000, whatever they're at now, and whatever kind of tenant they are, plus the right of first refusal to return. So not necessarily the greatest to be evicted, but I think financially, some of these people, and you were talking to the cost. So I think in that case, $20,000, you know, for that, and then to be able to come back to an upgraded or updated unit, I think that is part of what the city council was talking about. And so when we look at this, and there was discussions about this and what council directive is, and I think that kind of is some of the thinking there. So that's just one example. And then as to the 30-day notice question and the affirmative whatnot, so the staff proposal is that they have to wait the 30 days, or if the landlord has affirmatively declared that the housing service will not be restored. I would read that as an attorney, and I would direct staff's reading of that to be that filling in a pool with concrete or however they do it would be an affirmative declaration that would waive that 30-day notice. So, and I think the manager has explained it correctly, is that we do want to give landlords time, I think, you know, on, you know, like house cleaning, you know, that comes up a lot. We've seen services go up and down. You know, do we really want to ding them right away? I don't know, that's a policy discussion, but I think in this, the way it's proposed, I would say filling in the pool, you know, typically it's going to be, hey, let me have the house cleaners come back, and then the landlord writes back and says, no, we can't afford it. Okay, you've affirmatively told me, but it can also be a physical action. You know, filling in the carports with, you know, construction equipment and taking them down. That's how I would read this, and that's how we've written it. But I understand your point.
When does, can you remind us when someone files for a hearing, for a rent reduction hearing, when, and the hearing examiner, let's say, agrees with them, grants them a rent reduction, when does the rent reduction take effect? Not till the order is given, I don't think, but.
Correct.
So, you know, sometimes it takes us a while to file, and not because of the tenant or the landlord has done anything wrong, but it just takes us a while to get the hearing to happen. And maybe even one party needs a little bit longer or asks for a little bit longer, and that creates a little bit of a delay. And I've seen in some cases, and maybe it was just COVID, maybe there's a smaller time frame now that the hearing examiner has to give the decision, but the hearing examiner can sometimes ask other questions or take a while to form the decision. So all those things make sense or are part of the cost of administrative justice, I guess. But in this case, the landlord is taking the initiative and saying, starting this date, we're getting rid of this thing. And the reason they're notifying is because they know that people care, or, you know, they know that this would be of interest to people, or they're required by law to notice. So I'm just saying that that also carries a little bit more weight and needs to be resolved sooner. And by allowing the tenant on day one to file, that automatically gets rid of, you know, maybe a week, 2 weeks, and maybe even longer, depending on the situation. I understand that the landlord needs time to resolve it, but in this case, I just see this as different. Whether we're talking about filling in the pool or saying that, you know, we're only gonna have one dryer instead of 2 dryers starting on this date. Once the date is set and they turn that other dryer off, there's no, can we have it back? Like, they've taken that action. So that's why I feel so strongly about, we just don't need a time, the 30-day notice or countdown for that, for those situations. Thank you.
Commissioner?
Thank you. It just came up to me that going back to that 3 months versus 6 months, the relocation monies, the payment of requirement to pay the full relocation monies, fees, and the right of first refusal, these two provisions were there for when the work would have lasted 6 months, or this is something new. You know, I just wonder if these two elements were there in the ordinance originally.
Yes, those are not part of the amendment, so those provisions were originally part of the code.
Okay, so All right, that's a good thing. So it's not something new. But again, because it's reducing from 6 to 3, that's a good thing. But also, a landlord, one may think, oh, this is kind of great. It's just, this is a way for me to kind of circumvent ours, get rid of this old rents. And all I have to do is just come up with a plan that I have to work in this unit or in the building. That would last probably longer than 3 months. So how we ensure, what will be the mechanism to make, to kind of I would say guarantee that this is not going to happen in the city where, for those units where the rents are very low because the tenants remain in the unit for 25, 30 years. And that's the beauty of the rent stabilization in our city, right? And now the landlord will think, obviously, this is the older apartment buildings that require a lot of probably attention and work. And oh, there you go. All I have to do is come up with a 4 months or 3.5 months plan, and the tenant is out. So how do we ensure that? What mechanism we have to guarantee that's not going to happen?
I think just one point of clarification here, it has to be uninhabitable. This is usually because it's been determined uninhabitable due to a natural disaster or a fire. So this isn't a situation under this code where the landlord can say, well, I just want to update these apartments, I have to renovate things. This is, the city has said, city officials have said, this unit is not inhabitable, you have to fix this, and then the tenants can't stay there any longer.
Okay, it's based on the city's findings.
Exactly.
If the unit is uninhabitable.
Yes.
All right. Okay. So that makes sense now. Thank you.
Not be a case then like the situation in Los Angeles where there had been fires in the past, and when they went in to look to see what do we need to do to prevent this from happening again, or what do we need to do to bring it up to code to save to save lives, to prevent fire in the future, they came up with a plan that was meant that they had to redo pipes that was going to cause so much disruption, according to the landlord, that they were going to have to move people out. So it's not the city saying that we've red tagged this and you need to fix it immediately. This is, let's say, comparable to a couple of years ago, a building just collapsed in Florida. We find something in a building right now, or the landlord does, that he needs to do something to save this building. That's kind of a stretch, but I'm just worried that not giving the tenant, why can't we just make the tenant, either give the tenant the option of accepting if they don't want to have the 6 month of hassle of living off-site and all that other stuff, then let them be the decider, whether they decide to stay for 6 months and live off-site in this capacity, or take the relocation fee. Another thing I was thinking of, if somebody were to do a 4 month thing, so at 3 months, you take the relocation fee, you find your new apartment, finally find a new apartment that you can afford and you like, you get in there, well, the building becomes available again, you're stuck in your lease for a year. I mean, so that's going to cost more money. So maybe if within a certain amount of time, if the construction doesn't take as long as they thought it was, or within a year, 18 months, then the landlord has to pay for their move back or something. I just want to protect the tenants so that they're not being kicked out for nefarious reasons.
Anything else? Okay. Commissioner Bass?
You hear all of our comments here, so help me with the process here. This is the first time we're making a recommendation to the City Council since I've been on this commission. So what is the process from here? Because I don't think we have language in front of us that I'm comfortable voting to recommend or not recommend.
The process is that this would go before the city council afterwards. Generally, that's done with commission recommendation. I think, and I'll confirm here, that it could be at staff discretion even without commission recommendation, but I'm not certain on that. Kellen, would you?
Yes, if staff wanted to bring this to City Council, they could without the Rent Stabilization Commission's recommendation. But generally, what would happen is you would make the recommendation that would be included in the staff report that is presented at City Council when this item is brought to the City Council members. So if you did not have this discussion, everyone said, oh, we love what staff presented perfectly, it would be, you would be recommending that the City Council approve the resolutions that are attached here as they are written. If there are changes you want to make to your recommendation, those are as you see fit. You have to have the votes for that, but then that recommendation with the modified language of whatever you see as the changes you want them to be would be included in the staff report. And so the City Council would see Rent Stabilization Commission had a discussion on X, Y, and Z, and their recommendation is X, Y, and Z.
So could we make, if I were to make a motion, just hypothetically, if I were to make a motion to say that, let's say, and we numbered them 1 through 5, or 1 through 4, 1 through 5, that on 1 through 3 and number 5, we ask staff to take our comments into consideration when presenting to the City Council and let you go off and do what you want to do. But on recommendation, or on number 3, the Rent Stabilization Commission wants to formally recommend the City Council amend their resolution to, or that we're going to recommend that the ordinance be changed to ABC, and we listed off exactly what we want, and that passes. Would that be appropriate, or do you?
Yeah, so I'm looking at the staff report statement of the subject, and when you say 1, 2, 3, 4, 5, there's no numbers on there,
I
but
know,
you're talking as if there are numbers. So number 1 would be implementation of AB 1620. 2 would be amendments to RSO section 1752, 01013, and I'm reading them out loud so it's on the record and for people at home. 3 would be amendments to RSR 20001. 4 would be to 60002. And then last, 5th one would be amendments to RSR 60041.1. Is that how you're phrasing
Correct.
that?
Yep, exactly.
And the way it would work is there would need to be a consensus on if we're going straight with staff's recommendation on 1, 2, 3, 4, 5. So we couldn't say Commissioner Bass likes this idea and the chair likes this. So there would need to be a consensus on what that modified language would be as to each one, if any.
To simplify it, number 4 and the issue around noticing that there's going to be removal of a housing service is the only one that I'm still kind of hung up on. The other 4 I would be, so number 4 I have an issue with and I want to keep talking about. 1, 2, 3, and 5, I would support staff's recommendation.
And I would say the same, except that I would ask staff on at least number 2, express our concern that we don't want the landlords, this somehow being manipulated by landlords to evict tenants. I mean, I know the council's probably already thinking like that, but I think we would just like to make that part of the record that we're concerned about. So would we first want to do that? Do we want to just first agree that
Yeah,
1, 2, 3, and 5?
I'm fine. I agree with 1, 2, 3, 5, and the 4 I want to hear.
I support your statement of concern on number 2 as well.
I do too.
I think there's a majority for that.
Yeah, me too, but the manager explained some kind of fine with that. So, but if the commission wants to make that specific kind of a mentioning that, I'm fine with that too.
And just for staff's clarification, so number 2, you're going as is, but it is the recommendation of the Rent Stabilization Commission that City Council thoroughly review this language to make sure that landlords do not have an ability to exploit this section to the detriment of tenants.
That
Sure, I mean,
sounds
that's-
right
yeah.
to me.
That was more general, but sure, yeah.
And I think our council will be there, but it's good that we're on record that way.
Yeah.
And then Can you point us to, for the number 4, for the issue of the removal of a service with notice, can you point us to the right page in our book of the actual resolution or ordinance that we would be, that references that, or that?
I don't actually have the book myself. I pulled it up from the website, so I have just the resolution attachment.
Is that the
I
one?
think it's page 165.
Okay.
And so it would start, it says, it has a draft watermark on it. It says resolution number 24 dash, a resolution of the City Council of the City of West Hollywood amending rent stabilization regulations 20001, thank you very much, 60002 and 60041 dash 1.
And so which one is it that we're?
And you, Commissioner Bass, you said 165?
Yeah, that's the second page of the resolution you just
Yes,
read.
164, 165, and 166 is the full resolution. And so the underlined, double underlined is what would be added. And strikeouts are obviously strikeouts that will be removed if approved.
So this is worded a little bit differently than what the staff report was, but the addition would be in cases where the landlord has provided written notification. That's right, where I'm looking at, right? That's what the change we're making?
Didn't you want to remove, provided that 30 days has elapsed since the service of written notification?
Yeah, and that the
Yeah.
tenant would need to serve the written notice.
Yes.
But I'm trying to form a sentence now without those words. Or can we just say, in cases where the landlord has provided written notification that a housing service will be reduced or removed at some future date, the 30-day requirement of notice shall be waived to file an appeal, or to file a rent reduction?
Once the service has been removed?
Yeah, I'm sorry, once the service has been removed. It's upon the removal of the service. I'm just making up words, adding more words to it.
Except the way that I'm reading this is that the way it is now, if they give you 45 days notice and that same day you're like, hey, no, don't remove that service, you could file it 30 days. You wouldn't have to wait for the 45 days for the service to actually be removed. Or am I
If they
misreading that?
affirmatively said we're not remedying it. So it's still
Help
give
me
them-
understand that.
Commissioner Kirpies, I couldn't hear what your...
Oh, I said if they said we're affirmatively not removing it, or we're not remedying it.
So the underlying language that we have here, which starts with in cases where the tenant still has to serve the notice regardless, and I know that was one of your concerns, but the tenant would serve the notice, but that last line, or the landlord has affirmatively declared, and that would be, and what I spoke to earlier is if you saw the pool filled in, that waives the 30 days because the catch-all there is provided that 30 days has elapsed or the landlord has done X, Y, Z, the affirmative declaration. So it's either or in that situation. And so in that situation, you would still have to send the notice to the landlord, please return this. It does seem a little backwards or silly because if you fill in a pool with concrete, why are you sending a notice? But that would be the process. I go and see that they've filled up the pool with concrete. I send them a notice that day. It would be my legal reading and my direction to staff to interpret that as an affirmative declaration could be many things. It doesn't just have to be an email or a phone call back from your landlord saying, I will not return that housing service to you.
But wouldn't the, in the case you just described, wouldn't that, couldn't the landlord say, oh no, we're going to fix it. We're going to give them a better deal. We're going to reduce their rent or something. They still have, under that, if they claimed that, they'd have 30 days to follow through with it.
I don't think so. I mean, these are very fact-specific examples, but staff is the one that determines if an application is complete and appropriate under our code. And so if the landlord tried to be sneaky, I guess, they filled it in with concrete but said, we're going to undo that and give them a deal, they've still lost a housing service, which would make them eligible for an application for a reduction in rent. And so they file with the city reviews it. Staff may come to either management or myself on the legal side and say, hey, is that 30-day window waived because of the facts that we see on the ground? And so, it's going to be a fact-specific determination, but in the example I've used, I would say yes, they've affirmatively declared by filling in the pool with concrete that they will not be restoring that service, and then they can go forward with the hearing process.
So why can't we say that we're waiving the requirement of any notice at all, and the tenant can provide the notice that the landlord gave? I'm just trying to get rid of any of that time frame. And I know you're saying that that's what you would do in that situation, but I don't know what the next person would do in that situation, or what the staff on Thursday might do in that situation.
So the commission can recommend whatever they wish to the city council.
So I think if the landlord sends you a letter saying, I'm taking away this housing service, they have affirmatively already said, we recognize this is important to you, and we're getting rid of it. And if that is not provided to you with a corresponding rent reduction that you agree to and they agree to, then I think that's the point that they should be able to file for a hearing. That's where I'm going on this.
That's exactly where I'm at. So I think
people smarter than me help me come up with the language to say that.
So I think we can get there by waiving the requirement.
I think what I would recommend here is leave this as is, and then add a further sentence that explains what you want. In the event that a landlord has provided written notification of the removal of a housing service, comma, the requirement that the tenant, how is it written here? That the tenant serve written notice demanding the restoration of the housing service is waived.
Okay, so let's, instead of adding a sentence, why don't we just remove this whole final 1, 2, 3, 4, 5, 6 lines. So it says, in cases where the landlord has provided written notification that a housing service will be reduced or removed at some future date, and then the line that you said.
You want to remove after future date?
Yeah.
So in this situation, I think the intent of what this is they're saying we're going to remove, and again, I think council's direction and interest is that it's not always going to be something extreme like a swimming pool or something. It might be, the monthly housekeeping services that come sweep outside. I think there wants to be a balance struck there in giving the opportunity for the landlord to say, oh, either one, I didn't know that was the law in the city. Ignorance of the law is no excuse, but now I'm on notice, I need to do this and bring it back, or there's, an opportunity for dialogue between the landlord and tenant on this issue. So if, in 3 months I'm taking this away, I can't afford to pay for the housekeeping anymore. That's, I think, where, and then there is a little bit of an issue with things like due process and Costa-Hawkins and changing of the rents without notice to a landlord. And so, I think they're still going to have enough due process there, but I think the way the code has been written over time is to kind of respect the landlord's rights as well. You know, we talk a lot about the tenants here, but it also we have to balance the legal rights that landlords have as property owners for their different rights.
The status quo is well balanced towards the landlord because even though the way our system is set up, just the fact that the tenant has to say, hey, you took this away from me, means that there's going to be delay. Maybe it's 10 days, maybe it's 30 days, but there's a delay to the benefit of the landlord that he's removed a service and is not going to have to compensate the tenant for it by any means. So the only one who loses in that situation is the tenant. And what I'm trying to do is reduce that. So I'm not trying to disadvantage the landlord. We're only trying to, when they've taken upon themselves to say, I'm going to, at this certain date, remove a future service, then the tenant should not have to wait to file the hearing. They're still going to wait for the hearing. They're still going to lose out. At the end of the day, they're still going to lose out. But that's a win, I believe. So the reason I want to make sure that we're doing this one differently than the rest of them, and I want to make sure that the commission is recommending this change to the, is this an ordinance or a regulation?
This is a regulation.
So the reason I want to make sure that the motion is actually the recommendation from this commission, because that requires action to be taken. Either the council will agree with us, disagree with us, or they can remain moot on it, and it will become law. So I want them to participate in this conversation, and if they disagree with us, that's fine. That's their role. But I want to make sure that this is put in front of them like this so that they can make the final decision, or pass it on and not do anything on it. And it ultimately becomes law. But that's why I want to make sure that the word recommendation, that the commission is recommending specifically this be in our motion to move forward.
If you have language you're comfortable with, it sounds like something I would second. Sorry, I'm putting it on you because you've been drawing a lot more notes in this text.
I keep crossing words out, but it doesn't help. So why can't we just say, in cases, as it says now, in cases where the landlord has provided written notification that a housing service will be reduced or removed at some future date, upon its removal, upon the service or whatever it is, upon the housing service that is removed, the 30-day notification period is waived and tenant is eligible to file for a rent reduction hearing immediately. And maybe we can wordsmith that a little bit, but.
Does the tenant need to object at all? At any point?
I don't believe so. Their objection is them filing and saying, look, this is a service I don't get anymore, and I want a hearing.
Because the landlord is noticing them, that is working in opposite of the tenant noticing.
The landlord's already telling them they're going to lose a service without
Okay.
offering them any. Do you want to improve those words?
No. This is your recommendation, and we'll go back and watch the tape and make sure, as you said it there, it is clear enough when I go back and watch the tape what you've said, so I don't think it needs specific wordsmithing
Okay.
To get your point across.
Especially since it's a recommendation, not a final resolution. I trust staff to get the intent of this commission.
But my motion will be that this is a recommendation from the commission, but I'm okay with, as long as what he just said. I'm okay with what he just said and putting it into words, but that, I want it to be a recommendation from the commission to the city council.
If that's a motion, I'll second it.
That's a motion.
Okay, roll call.
Can I have staff clarification before we do
Yes.
that? The motion is that you are making a recommendation to the city council as staff has recommended, with the exceptions of number 2, which we've already gone through what number 2 is, to have city council take an extra long look, we'll wordsmith that, at making sure that landlords do not exploit this change to the detriment of tenants. And then number 4 is going to be the staff changes with your amendment to those.
Yeah, we're recommending the amendment to,
Correct.
yeah.
Because there's, in number 4 is a lot more of a change than just, actually, it might not be, but yes, we will amend staff's language to include what you have just said on the record.
I mean, or staff can still recommend their thing, but the
Correct.
commission is recommending this.
Yeah.
Okay. Then yes, that would be my motion.
I'm fine with that, what you recommended, although I didn't have a problem with the original version, but after all this discussion and your recommendation, I find it reasonable and there is no objection from my side.
Okay, so I have a motion from Commissioner Kerpes, a second from Commissioner Bass. Ready for roll call?
Ready for roll call.
Commissioner Bass?
Aye.
Commissioner Kerpes?
Aye.
Commissioner Topshin?
Aye.
And Vice Chair Moore.
Aye. Motion passes. Okay, anything else for staff right now before we move on? The next item is item 9B, election of the chair and vice chair.
Good evening, Vice Chair and Commissioners. I am the City Clerk designee for tonight's election. So before we start the election procedures, I just wanted to give a list of what commissioners were eligible for chair and vice chair, and we also have a special public comment. So let's get started. So the commissioners that are eligible for chair would be Commissioner Bass, Commissioner Kerpes, Commissioner Moore, and Commissioner Topshin. Eligible for vice chair would be Commissioner Bass, Commissioner Kerpes, and Commissioner Topshin. And before we get into the procedures, do you have a comment?
I have a question. Where's Commissioner Rory on that list?
He is not here tonight, so he would not be able to be nominated because he won't be able to accept.
Really? Okay, thank you.
So actually, now is the appropriate time. We talked about this earlier. I'm not sure if this now is the appropriate time, Chair.
Are we allowed to ask questions at this
Yes.
point? Okay.
So my question, and maybe there's a motion, but is now appropriate time to table this discussion until the next meeting where Commissioner Rory and hopefully more commissioners can participate?
The commission is able to make
To make a
that-
motion on
Yes.
that? Okay. How,
And the chair has already agreed to stay another month, right? Yes, I would make that that table, or I would table.
Do you want to discuss
Motion
it?
to table.
should we, okay.
I have discussion on that before we.
I think, yes, let's have a discussion. Commissioner Bass?
So a couple of things. One, we don't have a chair, and we have a vice chair who's incredibly capable, and I know we're not making nominations, would be my first choice for our next chair. So in the absence of our vice chair, we don't have leadership for this commission. The other thing I want to point out is that we have only had a full commission of 7 members here twice in 2024. So even though when former Commissioner Martz resigned, he announced it in February, and that seat is still vacant. And it takes at least a month to get from time somebody's appointed to this commission to get here. So that means the soonest we could make this decision with a full commission would probably be September. Then we're facing an election in November, and we know for sure that Councilwoman Shine will not be returning to the council. And depending on who replaces her, we could have a brand new commission. I know we're not supposed to talk politics while we're up here, but we don't know if I'm getting these all mixed up. Mayor Erickson will be returning to the council or not. You can look online to find my opinion on that. But we could have a very new commission, again in December. So I just don't think that there's a perfect time. And if we wait until we have a full commission in September, now we've reduced that chair and vice chair to a 9-month term. We're pushing it in December with new people. On top of that, Commissioner Rory and I were sworn in to the Public Facilities Commission together in 2013, and the first night we were there, we were asked to choose between Cole Ettman and Donna Sauer as our vice chair, and that was one of the most awkward things, and it was actually the two of us who motioned and seconded. I motioned, he seconded. I had to go back and look at the minutes, I didn't remember that, but to postpone the election after we were even brand new commissioners, because here I'm trying to choose between two people I met an hour earlier. And Commissioner Paris, Commissioner Designee Paris, who's joining us, he and I worked together briefly 12 years ago for a couple of months, so I kind of know him, but like, how is he going to choose among 6 people he's not worked with? So personally, I'm of the opinion that we should move forward with this and have leadership for this commission, and so I would oppose tabling it.
I also wanted to add, and I should have mentioned this earlier on in this discussion, but I did speak to Commissioner Rory this morning, and he wanted to share with the commission that he is okay regardless if the commission does decide to move forward with it, or if the commission decides to table it, he will support what the commission decides.
That's the last thing. I did talk to Commissioner Rory as well, and he would be open to a nomination. I did have that, but that's secondhand information for everybody here.
Commissioner Chopshin.
Yeah, Madam Chair. So I think I will be fine to just do it tonight, and we already postponed it, I guess, once or twice, I guess, right, or once.
We were supposed to have it at the last meeting.
Right. So I think we can just do it tonight.
Yes. I'm also okay with doing it tonight. I'd prefer to do it tonight, to be honest with you. So let's do it.
I guess I'm outvoted on that one. But just if I could make one comment that there are 4 of us. There's been one other appointment already made that you told me earlier. There's been an appointment made for this commission. And so, and we know that one commissioner is at home sick. Anyone who isn't here tonight is basically publicly saying it's okay if you move on without me, because that's the fact. So again, I'll vote. I'm going to vote no for all of you.
We have a wonderful group here to choose from, of a lot of experience, and I think we should move forward. Do we need to take a motion on that at this point, or can we?
I don't think I got
Does
a
your
second.
motion?
I don't think I got a second.
Oh, you didn't. You didn't. Correct. Okay.
So we'll move forward with our public comment, our special public comment.
Our special public comment may come up to the podium.
What a fun Rent Stabilization Commission meeting. Josh, such a stickler for the rules. Jesus Christ. But, all good. I appreciate the conversation. It's great to see you here. I was trying to get here for original public comment, but I had 5 different Zooms at the same time, which is almost a record for me. The record's 8. But I just wanted to come because I just wanted to come say hi to Tina. I know Tina's let the proverbial cat, or in her case, dogs, out of the bag. I know she won't be coming back to the commission. And don't worry, I already have someone that's being appointed, and we're gonna and I'm already ready to appoint them at the next meeting, so you'll be fine. I'm getting my people appointed. But I just wanna say, Tina, when I started as an intern, you were on the Women's Advisory Board. And I worked with you every 4th Thursday, and we would be there till 10 o'clock because the meetings would run long. And you became a friend, a confidant, a trusted advisor to so many in the city. We've done so many things together, I don't even know where to begin. And when you answered the call, to join the Rent Stabilization Commission, I think you said, I don't think I can do it. And here you've been for doing the job in such the most perfect, amazing, beautiful way. And you've never disappointed me, you've never disappointed the public, and you've just been the stable model for how I think about public service. And I wanted to make sure that, yes, after a crazy long day, I just came out here and publicly looked you in the eyes and said, I adore you, I love you, you are my friend, your service is exemplary, we will miss you. I know you're still keeping your place in West Hollywood, so don't think I won't reappoint you sometime in the future because I will be back in November. But ultimately, Tina, thank you. It takes a lot to be a public servant these days, and I owe you a debt of gratitude, and I couldn't have thought of anyone better to answer the call. And to all of you as well, but this is a Tina show. But I just wanted to say thank you so much, and I adore you to pieces.
Thank you so
That's it.
much. And I know.
And congratulations.
Thank you. I know I'm not allowed to speak back at public comment, but thank you. I adore you and love you.
Alrighty, back to regularly scheduled programming. So, how the procedures will go is I will open up the nomination for the election of chair, then I'll close the nomination period, and then I will conduct a roll call vote. And after the roll call vote, if there is a tie, there will be a runoff roll call vote on the top two nominees, and then the steps will be repeated for the vice chair. So, at this moment, I will open up the floor to any nominations for chair.
I would like to nominate Commissioner Bass.
And Commissioner Bass, do you accept the nomination? Any other nominations for chair? Okay, so I am closing the nomination since I don't hear any other nominations from the commission. And let's go through our roll call vote. So Commissioner Bass,
Aye.
Commissioner Kirpies,
Aye.
Commissioner Topshin,
Aye.
and Vice Chair Moore.
Absolutely aye.
Congratulations, Chair Bass.
Thank you.
Okay, so now we're moving over to Vice Chair. So I will like to open up the nominations for the Vice Chair.
I really want to nominate Commissioner Rory. If I'm called out of line, then that's fine. But
Legal counsel, any?
I have a text I can show you.
He would need to be here to accept that nomination under our rules.
May we get him on the phone?
So can we table the, okay, so I'm going to make a new motion.
Yeah, actually.
I'm going to
that's-
table the vote for vice chair until the next meeting.
Okay. Any seconds?
Second?
Okay, so I got a motion from Commissioner Kirpies, a second from Commissioner Topshin, and then I will do my roll call vote. Commissioner Kirpies,
Aye.
Commissioner Topshin,
Aye.
Commissioner Moore,
Aye.
and Chair Bass. Okay, motion passes, and the election for the vice chair will be postponed to the next agenda.
Now I passed it over
Oh,
Yes,
that's
to
me.
chair,
yes.
and I'm passing over the script.
Let's see.
We're on item 9C.
9C. Sorry, I was not prepared. Commission liaison appointments to other commissions and advisory boards. Is there any staff report on this? Any direction for us?
No staff report, but there was a list of the commissions and advisory boards provided in this staff report. I also have a copy if anyone would like to look at it. I can provide that.
My own take here is that this is kind of a waste of time. I don't know that anyone here, thank you, our Commissioner Moore had passed it on to me. Thank you. I was appointed a couple of these last year, did absolutely nothing with them. I don't know if any of the rest of you did. But particularly since it's, as we've been admonished by the city clerk, not to speak on behalf of our commission unless we have been given very direct, very specific direction to do that. I don't see what the purpose of this is, but I'm interested in what the rest of you think.
I feel the same way, and I think that we had this discussion last year as well, because we all spend a lot of time here doing this great work. Those are my thoughts.
Is this a kind of a requirement, or is this a mandatory thing, or this is a voluntary thing? Because I know that my interest is typically in the public safety, and I think I was appointed as a liaison to that particular commission, but time flies. And I didn't make to any, I think I did one time. I attended a Zoom meeting, but unfortunately I just couldn't make it to any other meetings. And as I said, time flies so fast, and it's been already 12 months. We just realized that, right? So I don't know if this is a kind of a mandatory thing or it's a voluntary thing, or do we have to, I don't know if you can get some clarification on that.
This is voluntary, so
voluntary.
if there is not a commission or board you'd like to be a liaison for, you certainly don't have to sign up for it, and there's not, we don't have to say, okay, there's 10, or, out of the Rent Stabilization Commission, we have 10 spots that need liaisons, so this is completely voluntary.
Voluntary thing. Thank you for clarifying that. And again, I really like the Public Safety Commission and the work they do and everything that has to do with public safety. And my interest will be in that commission, but I would feel guilty if I wouldn't regularly attend the meetings because I don't want to take anybody's spot. If any of you guys, if any of the commissioners will be interested in that, just feel free to take it. So, but that would be my interest, my choice.
I think to word it a little bit differently, we all think that these commissions and advisory boards do amazing things, just as we think we do a great job here. But I think that instead of assigning people to each one, and you're right, we're very restricted in what we could even do at them. And so what would we be expected of is kind of like bring the information that we learn from those commissions back to us to let us know. But I think that in practice, all of us do that already in our activities throughout our community. And some of us do catch a Historic Preservation Commission meeting on occasion or a Senior Advisory Board meeting on occasion. And I think that as any of us come across things in the community that we would like to share with the commission and the public, that we have been doing that in practice, and I think we should continue doing that. And I, for the last couple of years, haven't really been appointed to any specific ones because I just didn't have the time to necessarily commit to going to them. But I'm interested in a lot of them. It's just, I don't know if it's necessary to appoint liaisons.
My interest really is that if something comes up where we think we do need to liaison with one of these commissions, that we can make that determination and actually send the message that we want with our representative in that specific circumstance. And I think that would be a more appropriate as needed. And I would just say the rest of us should report back if there's something we hear in the community at any place, these commissions or boards or just in the community that we think the rest of the commission needs to hear. That would be my takeaway on this.
Sounds reasonable.
Hearing no objection, let's move forward with that. Let's move on to item 10, items from staff.
No items from staff at this time. Thank you.
Thank you very much. Do we have any more public comment?
No public comment at this time.
Thank you. Items from commissioners. Commissioner Kerpes.
Just want to welcome our new staff attorney, or whatever we call you.
That'll work. Legal counsel.
Sorry to put you through some extra work tonight. And then also wanted to talk about what an outstanding, amazing chair you have been the last year, or the last 2 nights, the last 3 meetings. Really, you have been great, and you've been able to step up as vice chair. Really appreciate it, and making personal sacrifice to be here for us, and we appreciate it. And I was hoping to keep you here one more meeting, but I guess the rest of them don't want you.
Yeah, at first, I want to thank you, Tina Moore, Commissioner. You've been really incredible in your position as vice chair, and then you stepped up as a chairperson for the commission. You did an amazing job, and very tactful, with a big smile, and allowed everyone to speak, allowed the commissioners ample opportunity to discuss and raise questions, and I appreciate that. You've been absolutely terrific, and it would be really, sad to see you leaving, right? So, and I want to congratulate Commissioner Bass. Great job as a commissioner, and I'm really happy you're going to be the next chairperson, and I'm looking forward to work with you in that capacity. And of course, congrats to former Commissioner Mart and now our legal counsel. So now you know
Thank you.
inside out of everything, right? So now you're gonna, well, the questions you asked as you were the commissioner at the time, asked the legal counsel, a terrific guy, John Natalizio. He's definitely going to be missed. Obviously, he's done an incredible job, and I am sure you are the best replacement for John Natalizio. So I'm thrilled to work with you now in that new capacity. You're awesome. So congratulations.
Thank you, thank you.
Commissioner Moore.
Thank you. I did write something just because I didn't want to forget anything. And to be honest with you, I've been serving the city for the last 14 years in two different capacities. I've been here for the last year, as you all know, and it's been a very bittersweet decision that I've had to make. But as the mayor said, I will be around and out, so I'll come visit at different times. I just wanted to say it's been an absolute honor and privilege for me to serve as Vice Chair on the Rent Stabilization Commission for the City of West Hollywood. Over the last year, I have enjoyed working alongside all of my fellow commissioners and former Chair Wright. I want to thank Mayor John Erickson for granting me the opportunity to serve the city and entrusting me with this great responsibility. Thank you to my fellow commissioners for your continued dedication to each and every meeting, for our insightful deliberations, and to our staff, Madam Secretary, Manager Kessinger, and our council, former Commissioner Marks. I also want to thank the residents of the city of West Hollywood. I'm so grateful for the opportunity I've had to serve the city both on this commission as well as the Women's Advisory Board. I felt so blessed to live in a city that sets an example for the rest of the country based on the decisions we make, the amazing community that we are, and the impact that we have based on right and just resolutions. I look forward to following the great work that you all do and will continue to do, and I will always hold my experiences serving the city in my heart. Thank you.
Thank you. I know we're all feeling the love at the moment, but I have a serious question, and then I'll bring it back so that we can end on a high note. And I apologize for having to do that. But tonight we had a really robust conversation about the RSO changes, and I sincerely appreciate my colleagues having that conversation. I think that we create a better product by giving staff and the city council those sorts of thoughts as residents. But my question for staff would be, a few months back in May, we heard we deliberated over something that was essentially the color of carpet. And we all said we hated the fact that there was no objective standard there. And I think that we could get to something that would at least give hearing examiners in this commission some direction. I think color is very subjective, and we might not be able to dwell down on that. But on that particular issue, I believe that there was some consensus on the commission that we wanted to address the ambiguity on that. So using that as the example, how would this commission initiate changes to the RSO on our part that are not just staff recommended changes?
So in that situation, if the staff wants to agendize something, they would make a motion to do exactly that. I would just note that staff report agendas are staff driven, so it would be a recommendation to staff to put it on the agenda. There's no guarantee, and also as to the timing, because staff dictates the length of the staff reports depending on how much work there is. So it would be a motion if you wanted to do so to discuss XYZ, and to request staff to put that on a future meeting agenda.
Personally, I don't know that it's worth it for that one issue, but I think that clearly not in the foreseeable future based on the look ahead calendar, but next time we're facing one of those situations where it is a meeting canceled for lack of agenda items, it might make sense to have a study session sort of situation where we talk about potential RSO changes as the item for that night. That would be my personal inclination. Commissioner Topton, did you?
Yeah, no, I'm fine, whatever you said, yeah.
So if staff could keep in mind maybe a study session for the next time we have a lull in appeals, which, who knows, maybe none of us will be here at that point in time.
And Chair, if I may,
Please.
I wanted to ask if the chairperson would have the right to recommend something directly to the staff to agendize, or that's not?
No, it would need to be a motion and pass with a majority vote.
But can the chairperson bring something up at the commission meeting during the commissioner comments or at any time? Recommendation to agendize something for the next meeting?
No, it would need to be a motion with a second and a
Okay.
majority vote. You can say, your commissioner comments are pretty, open to what you can say as long as it's within the relative purview of what the RSC does, but you wouldn't be able to have a discussion on that because it's not agendized and state law needs it to be agendized.
Okay, all right, thank you.
Well, my inclination is that we just kind of keep a running tally of these ideas and have that study session. And if we get too long of a tally, maybe we would need to make a motion to have that be an agenda item at that point, unless we come up with something pressing. So getting off the business side of things, I too want to echo the thoughts of my colleagues in thanking Commissioner Moore for an incredible year. It was wonderful to work with you. You have been exemplary in your leadership of this commission, and it's just been a real honor to serve with you. And I echo my colleagues and the mayor in thanking you for your service to the city of West Hollywood. West Hollywood is better because of your service, and I'm grateful for you. I am also grateful for my colleagues for giving me this opportunity. I went down a rabbit hole the other night and was looking through old city council meetings, and I think I'm one of, I don't think, I'm going to just own my nerdiness here. I'm one of 10 people who has served on 3 or more commissions in the city. Commissioner Kirby's, you're also one of those, although you're only on public facilities for about 2 months. And unable to see old minutes from the 80s and 90s for some commissions, but the only person who potentially served as chair of 3 commissions would be Sybil Zayden, and I'm not sure if she did or not, but it's really an honor to maybe be the first one to chair 3 different commissions in the city, and I'm cognizant of the fact that I have an incredible opportunity to serve, and thank you all for that opportunity. I want to announce that I will not be here at the August 22nd meeting, so that that's on the public record. So let's elect a vice chair next meeting, please, and wish Commissioner Rory the best in that he feels better soon. So hearing nothing else, I'm going to adjourn this meeting of the Rent Stabilization Commission. Our next meeting will be held on Thursday, August 8th at 7 p.m. in the West Hollywood Park Public Meeting Room, these council chambers. Thank you.